say hello to everybody. Many of you I think I know them. Thank you for the invitation and congratulate Sima for what is will certainly be a very successful event. It is, when you look at the agenda and variety of presentations that we will have today, we may conclude that this will be a very successful event. I was for 25 years at the European Commission, working always with labour law issues and industrial relations issues. I have been responsible for a number of directives, many of which you know, I think, the European House Directive, European Company Statute, Information and Consultation. And I was also involved in restarting, corporate restarting for a number of years. And I was also involved on launching at the very start of this dossier on transnational company agreements. Back in 2005, when the Commission announced for the first time some kind of initiative in this field. I'll come back to it. I think it is useful for you to give you an overview of my opinion on what is going on with regard to this kind of agreements. I have a list of subjects that I will to address very quickly, very briefly, and in a very factual manner, without going much detail, because many of the subsequent speakers will develop these and other issues in a better way than I could. First of all, the definition, what is this about? Secondly, the mapping of the agreements. What are we talking about? What kind of agreements we have? Third, why this development? Why did companies and worker representatives, unions and other worker representatives start to conclude this kind of agreements? Then some important topics for discussion that are still being discussed and will continue to be discussed in the future. First of all, legal status of the agreement, the quality of the parties that sign, a special case of the agreements on restructuring that are, in my view, the most important ones, at least in Europe. The issues around the effectiveness of the agreements, and what could be seen as a sort of slowdown of dynamics around this conclusion of these agreements. And then I will finish with the European development, what has been done by the European Commission and what is foreseen in the near future. First of all, some words on acronyms that we use. TMC is transnational, multinational corporations, transnational companies. ECA is a transnational company agreement, called entreprise transnationale in French. And in some cases, people say also transnational collective agreement. And then we could divide this broad category into two. The international ones, IFA, that means agreements with a scope that goes beyond the European Union, and the purely European framework agreements. We call them framework, but this qualification is a bit curious, because not all of these agreements, far from that, can be considered as a framework. A framework agreement is an agreement that is designed to be translated into lower agreements by concluding similar agreements at lower level. And this is not the case of all the agreements that we call framework agreements, but this is perhaps a detail. Then we have a definition of agreements, and it is important to distinguish agreements from other initiatives that are that have emerged in recent years at the initiative of multinational corporations, PCAs. And the main elements of this definition of international company agreements is an agreement with commitments, reciprocal commitments, signed by two parties, a transnational company and worker representatives, a different kind, by the way, and which cover relations between employers and workers or working conditions. These are the main elements of these agreements we are talking about. And it is to precise this because this minority here is bilateral nature. And this allows us to distinguish immediately these kind of agreements from other unilateral initiatives like codes of conduct and other CSR initiatives. So, how many agreements are there? Without taking into account the 1,300 agreements, also agreements concluded to implement European Councils, and the number of other ones with a wider scope, worldwide works councils, and also the agreements that were concluded to establish European companies in accordance with the European directives. So without taking all this into account, there were, by the end of 2013, and these are the latest figures I found, 267 transnational company agreements, of which almost half were international ones with a wider scope than the European Union, and 127 purely European agreements. More than 10 million workers worldwide are covered by these agreements. And they are concluded in the most important sectors of our industry, metal industry, chemical industry, telecommunications, banking, and so on. It's not a surprise that these sectors are the ones that were chosen to conclude these agreements because they are the most internationalized ones. And most of these agreements, more than 85%, are agreements concluded with companies headquartered in the EU. That means that even if there are companies from other parts of the world concluding these agreements, most of them, this is a mainly European phenomenon. With regard to international framework agreements, 84% of them, that means 118 out of 140, are based in continental Europe. That means that this is, first of all, a European phenomenon, and then it's a continental European phenomenon. I mean, there is only one, as far as I know, one agreement concluded by a British company, for instance. And more than half of them are French or German based. There are 30 in France and 26 in Germany. And then you have other countries that are very important in this topic. Sweden, for instance, with 14 agreements. Norway with 9, Spain 7, Italy 6, and so on. It is also important to recall the fact that some transnational companies have concluded many agreements. One case is Danone, which was called previously BSN, that has concluded already 8 successive agreements on different issues. And then you have 22 non-European agreements, that means agreements concluded by groups that are based outside the European Union, 6 Brazilian, 4 USA, 3 South Africans, 2 Japan, from Japan, and so on. And one characteristic of these agreements that distinguish them from the purely European ones is the fact that they mainly cover issues related to fundamental labor rights and what is usually called CSR issues. They do not cover other topics that we see normally included in purely European agreements. So these are agreements that have a scope, a worldwide scope, or at least a scope that goes beyond the European Union. And then we have European agreements, 127, as I mentioned before. It may seem not much, this number, but if you look at the fact that most of these companies have European councils, and you compare the number of transnational corporations in Europe with the European councils and the number of those companies who have signed these kind of agreements, you conclude that many of them have already these kind of agreements. These agreements with the European ones are signed either by European councils or by European Trade Federations or by both of them. And they are European in scope. That means that they cover all subsidiaries and establishment of these groups in the European Union. The preponderance of the French companies is even stronger than with regard to international agreements, almost half of them, and a bit less for Germany, only 17. And they deal with a variety of issues, more important ones, as compared with the national agreements. That means recycling issues, health and safety, social dialogue procedures, human resources management, training, qualifications and skills, CSR and so on. So we are looking at a phenomenon that has become extremely important. Even if there are lots of problems and lots of questions on them, the only fact that it covers 10 million workers worldwide gives us the measure of the importance of this phenomenon. Why has this kind of agreements been started to be concluded some years ago? I think that there are many factors. This has been studied, and there is a wide consensus on reasons behind this. First of all, the fact that we all know that the labor relations and employment relations for some years now have entered into a period of crisis, or at least of delay, following the economic crisis of the 70s and the policies developed in the 80s with a different role for the relative balance between employers and employees. Second big factor that influences the appearance of these agreements is the emergence of the international relations, labor relations agenda and arena. Many companies became international, and they need to develop policies that go beyond the scope of individual countries. So they are applying the same rules, or trying to apply the same rules and practices, same employment practices across borders. And so it is natural that from their part of companies, they are interested in developing some kind of framework for this international phenomenon. Same for worker representatives and unions, because they are also interested in developing this international arena for labor relations. There is an ongoing discussion on whether this is a good thing or a bad thing. And some see in this development an opportunity for economic development and greater social and political integration across nations, allowing, for instance, countries like China and many others to increase their labor standards, their quality of life, and approximate them from the higher standards that we have, for instance, in Europe. And others see this as a threat to existing high-level, high-standard countries or systems of rights and working conditions. This is a very important debate, ongoing debate, and you'll find this around the discussion on transnational company agreements. The first elements, phenomena to materialize this new international arena were codes of conduct. That means unilateral initiatives of some multinational companies to try to develop some kind of labor relations, new labor relations across borders. And then there was another phenomenon that came across some years ago that may be translated into the concept of CSR, corporate social responsibility. The fact that companies are worried at least about their image and try to limit damage caused by, for instance, bad labor relations or bad working practices in parts of the world with no protection for workers. So you have this concern from companies and also from trade unions on trying to behave well, generally speaking. But you have also a concern from companies and trade unions to increase their status across all over the world. And these kind of instruments are seen as a way to overcome what is called usually the governance deficit. That results from the fact that we have a global economy and we don't have a global social regulation. Social regulation is still national and depends very much on national systems of natural relations, of representation, and so on. This is less the case in Europe, within Europe, of course, because we have the European Union with many common features, with very important and powerful organizations of social partners, for instance. And so here we have a higher level of integration. So this is why these agreements have started to be concluded. After the unilateral codes of conduct, we have had many other initiatives. For instance, with ILO, common initiatives between multinational companies and ILO around what is called the main fundamental social rights. Multi-stakeholder approaches such as the ethical trade initiative that has a very important role in some sectors, and then transnational collective agreements negotiated between transnational companies and global unions or European unions with concrete relations. Well, there is a number of problems with these agreements, and mainly with European ones. Now I start speaking mainly about European agreements. First of all, the question of legal status. When this started, the question arose immediately, what is the nature of these agreements? What are the real obligations taken by companies and trade unions when they sign them? Is this enforceable, or is this just a statement, a political statement, a statement of will? Or will this require agreements at local level, binding agreements at local level? And all these questions arise from the fact that there is no legal framework for these agreements. And so they may be subject to what is maybe considered a very complex and not at all clear system of international private law. I'm not going into details, but this may even has led in the past to some litigation and some difficult questions to be solved. But what remains from this absence of legal status is the fact that these are non-statutory, self-implemented agreements based on autonomous negotiations. And this, of course, raises, on one hand, it raises questions about the effectiveness and many of the provisions that we found in these kind of agreements, and about the uniformity of their implementation in different countries. On the other hand, I think that it is reasonable to conclude that the absence of a legal framework has in some way facilitated the conclusion of many agreements. And the reason why we have now almost 300 agreements, maybe in many cases at least, results from the fact that the parties were totally free to negotiate whatever they wished to negotiate. And the nature of the text that was being discussed was defined by themselves, by the parties themselves. So this question of legal status is a little bit. Second issue is the issue of signatory parties. Virtually all the agreements are signed by multinational companies in Europe with the European consensus. And most of them, that means 92 out of 127, were also signed by European consensus. And 63 of these 92 only by European consensus. No other organization was involved. this is a big desire, because in most of our systems of industrial relations, bodies like the European Councils have a mandate, a remit that only covers information and consultation, not negotiation, not concluding agreements. And traditionally, in many of our systems, the negotiation capacity lies only with trade unions. This is how our system has evolved in Europe and in other parts of the world. And so this was a bit of a surprise when it started like this way, even if it was, in many cases, the result of the fact that many, if not all, of the European councils are composed by members of trade unions. And so trade unions were also involved, not only European trade unions were also involved in many situations. Anyway, this is an ongoing issue to debate, and that is why I think some European trade union federations have worked on this. I won't go into detail because I'm sure they will speak about it. But there are procedures to be put in place to give the European trade union federations a mandate to conclude these agreements under certain circumstances. And what we have seen in recent years is that the proportion of agreements concluded or signed by trade unions, European trade unions, is increasing a lot. It was only 4% in 2006, and it is now, in the most recent years, almost 19%. And speaking about agreements that are only concluded by European trade union federations without any kind of interference of the signature of the European consensus. But the role of the European consensus still is very, very important, and there is a certain tension around this subject. And the tension is somewhat limited because very intelligently, I think, the European trade union federations and the European councils have found a way to coordinate themselves in some kinds of problem. Third topic, important one, I think, is the fact that for some years now, many of these agreements, European agreements, have started addressing a very important issue, corporate restructuring. And this is important in some ways, a new development, because there, when you are negotiating on restructuring, you are dealing with the bulk, etc., of management priorities. And you are at the center of industrial relations, of employment relations. And you do it in many cases. You may see them in many practical cases. You do it in a way that is a real negotiation between management and workers' representatives, either on the way to conduct restructuring, and this is what we call procedural agreements, or that means the procedure for restructuring, or what we call substantive agreements, that means what are the obligations of management and workers' representatives and workers themselves with regard to conduction of restructuring. And this may cover things like guarantee of employment, obligations for training and so on, with employment, these kind of things. We have now in Europe 32 agreements, European agreements, that may be considered to be procedural, and 19 that deal with substantive issues. And it is important to recall this fact because I think it might be perhaps others would say, but I think these are most important ones. Ones that we give us more developments in industrial relations in Europe. It is important to remote, it's curious at least, to see that of the 19 substantive agreements dealing with particular occasions of restructuring, 16 were signed only by 3 companies, and all of them American, or with a big American difference. 4 General Motors, even if they are, it was their European parts, General Motors Europe, from Europe that have signed them. And third one was Daimler Chrysler, with a strong American economy, of course. All these companies, by the way, are based in Germany, European operations. So this may be considered to be a translation of the German system of industrial relations. Anyway, it is curious to see that companies descending from the American tradition, much more reserved on these issues, are the ones that have been more active on negotiating substantive agreements on restructuring. Another issue is the one about effectiveness of EFAs. I mentioned it before that these agreements do not produce immediate general effects. So it is necessary to have some kind of local implementation that throughout the groups if these agreements are to be put into practice. And of course this implementation, local implementation, must be carried on by management, local management and local workers. In these circumstances, it is of course more difficult to ensure uniformity of the effects of these agreements throughout different parts of the group, because these local agreements may differ from one to another, and they will certainly different because industrial relations is different from country to country. It's a slow process. It takes time to reproduce at local level what has been negotiated. Sometimes during the period of time at European level. And so these agreements rely very much on the existence of strong information, communication, monitoring mechanisms. And most of them, speaking again about the European agreements, do have this kind of mechanism, monitoring mechanism, regular evaluation mechanisms that contribute to a more uniform implementation. But anyway, effectiveness of these agreements is an issue. And finally, the last point is a question. The question is this one: are we witnessing a slowdown of this dynamic? What we have seen is that in 1994, the year when the European Response Directive was adopted, and there is a relation between these two realities, there were only 5 international framework agreements. From 2001 to 2013, we have had, on average, 9 international agreements and 9 European agreements concluded every year. And since 2011, a bit paradoxically, I think, the number of agreements that have been concluded has decreased. And this, you can see figures there. And this decrease, this reduction in hours, is only not dramatic in the case of agreements on restructuring. And this is really, it seems to be a bit contradictory, because we all know that this was a period during which there was lots of restructuring throughout Europe, with many companies engaged into very difficult, painful restructuring. So it would seem to be more adequate and more favorable for conclusion of this kind of agreements. Why is this happening? If this is happening, I think it's a bit early to conclude on this. There are some explanations that have been invoked. First of all, are we witnessing some kind of nationalization of industrial relations during the crisis? We know that part of the reactions of the investors to the crisis were national. And I'm speaking, for instance, about financial support given to company sectors and so on. Many of these was a national answer. And so, dealing with restructuring at national rather than at transnational level, European level, would be considered to be natural. The second possible explanation is the fact that we may be witnessing a flight into informality, and this may be also observed, I think, in some German European councils with this kind of agreements. So it means that the parties do not need anymore, or not in all cases at least, to conclude agreements. They just solve things in uniform, and this is anyway an important part of all our industrial relations systems. Things that are solved without documents, without paper. Another explanation is the fact that there may be a certain illusion about the modesty of the results that have been obtained with these transnational company agreements. I don't know. We don't know. We have to wait a bit more to see what is going on. What I think is that, in any case, transnational company agreements are certainly the most dynamic element of the European system of industrial relations in the last decades, during which we have seen less progress on some phenomena that seemed very promising some years ago. I'm speaking about transnational bargaining or cross-industry or even sectoral. So it's important to continue to observe and to monitor this phenomenon. So to finish, what will happen next? And now I'm speaking mainly about the European Commission level. First of all, the European Commission launched this process of discussion of disagreements and the possible need for the European framework 10 years ago, when we published the European Social Agenda by the time, and there was a call on social partners and many other institutions to reflect about the need for this. And the objective was by that time to have some kind of legal instrument, possibly a regulation, adopted before the end of the decade. Of course, we had afterwards the crisis that has changed completely priorities at the European level, and other factors that I don't want to touch now. They've also changed priorities at the European level, and what we can say now is that there is no political appetite at all from the part of the European Commission to intervene in this field and in many other fields. We have employment and social affairs, at least with legal instruments. That's what they have been for some years now. There was an important text coming from the Parliament 2 years ago on insisting on the Commission to think about such a legal framework, and asking the Commission also to, in any case, to promote the conclusion of these agreements. And what the Commission has declared in recent occasions is that it will continue to promote exchanges of good practice in debates, as it has been the case in recent years. There were 2 high-level groups established by the Commission with cooperation with social partners, companies, and so on. And those high-level groups gave rise to 2 Commission documents, staff working documents. The question of whether or not it should have a European legal framework was discussed, of course, during those debates. But the points of view that were expressed were very much divergent. And we see trade unions, generally speaking, trade unions in favor of such a legal framework, and it is seen as an official position on that. And we see Business Europe with lots of reservations, if not totally opposed to such a development. In any case, the Commission continues to support this framework, first of all by supporting financially the conclusion of these agreements and discussions, and this project is one example of this support. Secondly, by establishing and maintaining the European database on company agreements, European company agreements, framework agreements. This database is useful. It is very difficult to keep updated because not all agreements are traceable. Anyway, it is there. You can consult it at the Commission's website. And there are ongoing discussions with the ILO to try to extend this to IFES, to international framework agreements. And finally, there is an engagement from the Commission to produce a study on out-of-court settlement of transnational labor disputes, including disputes around the application or the implementation of the respect of transnational collective agreements. That's what I have to tell you. Thank you very much for your attention, and I'm willing to answer your